Good morning, everyone, and welcome to today's session on our end-of-year check, our end-of-year health check, current issues in employment. My name is James Matson. I'm a partner in our workplace law and culture team here at Bartia Perry. I want to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land, and pay my respects to their elders past, present, and emerging. Before Jade and I get started today, I would like to go over a few items so you know how to participate in today's event. You'll have the opportunity to submit questions at any time during the webinar by typing your questions into the box found on the control panel. You may send in your questions at any time during the presentation, and we'll endeavour to answer them during the webinar or at the end. You will also receive a copy of the slides and the recording of this seminar post the event. As I said, I'm joined today by my colleague, Associate Jade Bond. Thank you, Jade. So let's begin. So what we really want to talk about today is the issues, the current issues that are really bubbling away in the area of employment, and we promise that there'll be no mention of COVID other than to say this. We all know the New South Wales Supreme Court has upheld the validity of the public health orders recently. There's a full bench vaccination, mandatory vaccination case before the Fair Work Commission that's being heard on the 24th of November, decision early December. I think that's all we need to say at present. We're waiting. But like that area of uncertainty, what we're going to be talking about today is other areas where we are seeing uncertainty, but a movement towards some certainty. So we've got uncertainty, uncertain times, and we're moving towards some certainty. And we're going to talk about those areas. We're going to talk about casual employment. We're going to talk about whether a worker's an employee or contractor. We're going to talk about restraint of speech in an employment context by reference to a recent High Court decision. We're going to talk about recent changes in the area of sexual harassment, which is an evolving area. And then we're going to talk about something that you tend to see a lot, the Great Resignation. And hopefully that will give you an idea on what to keep a lookout for over the next 6 months as we move into 2022 and hope that it doesn't hold too many new surprises. So I want to talk about casual employment, and I know there's been a lot of talk in this area because, you know, in one sense I asked the question in a cheeky way, how can an area like this be so uncertain? And how can it remain so after the High Court has issued a very clear and decisive decision on that topic? So let's unpack that a little bit, because it is something that employers are still going to need to work through. This is sort of the journey we've been on. We began with what I would call the designation test, and that test was around for quite a while. If you engage and pay a worker as a casual, they're a casual. Couldn't be more certainty in that. We then had the casual model attacked and challenged, and that led to a number of challenges in the federal court, and then ultimately the High Court, which is seen at the bottom of that slide, where we have what is now called the no firm advance commitment approach or test. No firm advance commitment. And in respect to that, the federal court said, well, you look at the totality of the relationship, it's the vibe. and then you sort of work out whether or not there is no firm advance commitment. We then get to the High Court, and the High Court takes a narrower approach that says, well, let's look at the contract, and does the contract provide for no firm advance commitment? So that's the journey we've been on, looking at a very simple topic about whether someone's a casual, it's on their pay slip, they get 25%, to looking at it a little bit more deeply, and that created much uncertainty for business. So the Rosado case, which caused a lot of the attention and led to the change in the law, involved a worker, Mr. Rosado, who was working for WorkPac, and WorkPac placed him at another location to work, and he worked under a series of 6 contracts, or what they called assignments, and each assignment would be for a finite period. Now, in that finite period, yes, he worked 38 hours regularly each week, but each assignment was for a finite period. And he ended up working under 6 of those contracts over a period of about 4 years. He was paid as a casual. He wasn't entitled to leave entitlements. This was recorded in his contract. He was paid a higher rate because he was a casual, in satisfaction of not having those leave entitlements. But the full federal court said, well, when we look at the vibe of it, how can someone working 38 hours a week on contract after contract after contract not have a firm advance commitment? Clearly he did. He knew he was always getting 38 hours. And by looking at what happened in the relationship, the full federal court found he was not a casual employee, and happy days for Mr. Rosado, a lot of extra money. We then get to the High Court, and there's a reason why I'm doing this, because it is actually quite important in the journey we're going through at present in the area of employment law. But the High Court accepted the concept of a no firm advance commitment as being an approach to looking at whether a worker is a casual or not. But what they said is a firm advance commitment means something that is binding. It means something that is of an ongoing nature at the time you enter into the contract, And when you looked at the contract, it said, hey, 6 months, you can accept it or not, but we don't promise anything else beyond that. And the High Court said, well, there was no mutual binding commitment of an ongoing work relationship. And then when you looked at the contract, and the contract spoke about a casual loading, they said, there's no firm advance commitment here. And it's wrong to go looking at, well, how it all played out, because we're looking at the firm advance commitment at the time of engagement. And part of doing that was the High Court recognising, much like it did 8 years ago when employees tried to imply a term of mutual trust and confidence, they're saying we've got to give business, we've got to give employees, we've got to give people certainty. And the best way in which you can give the certainty is you look at whether there's a firm advance commitment at the time of engagement by looking at the contract. Now, the contract may be written, it may be oral, it may be from the conduct of the parties at the time of engagement, but you are looking at what is the commitment made at the time of engagement. So that provided a lot of certainty. Everyone was cheering. But that's not all that's been happening with casual employees, because at the same time, Parliament decided to get involved and legislate, and we certainly know over many years there's been a lot of work towards this concept of casual conversion. And that as a concept, my goodness, doesn't that bring in a degree of uncertainty for business? Might have been better to just leave it to the High Court. But what we've got is a industrial concept, now a legislative concept in the Fair Work Act, though it's replicated in many awards, both federal and state level, of a balance being struck that if after being a casual employee, because there's no firm advance commitment, the reality works out to be a little bit different, then you can have the opportunity to convert. And this is where, for business, it becomes a little bit of a test the wind, bit of the vibe, try to work it out. Because certainly it is under the federal scheme, and certainly in some awards, it's quite clear that the time you assess the eligibility to convert is at a point in time. Under the Fair Work Act, an offer has to be made within 21 days after the end of the 12-month anniversary. But you're looking at conversion where the employee has a regular pattern of hours on an ongoing basis. Did anyone decide to define that? No. Did anyone decide to give indicators of what you think about or what you can look at to help you work out what a regular pattern of hours? No. So one of the challenges, one of the areas of uncertainty for business, what is a regular pattern of hours? Is it someone doing a regular pattern of 20 hours each week? Or does that 20 hours have to be always on the same day, so that way it easily converts to permanent? What if that 20 happens to be on a Monday, Thursday, Friday, then it happens to be a Saturday, Sunday, Monday, and it just ebbs and flows? So what it talks about is a regular pattern of hours. I think that concept does capture in not only the quantum, but when it occurs. But again, all of this will be fleshed out when we start having disputes over what that means. Then what we have, which is set out at 3 and 4, is the ability of the employer to refuse to make an offer to convert if there are reasonable grounds. And what is reasonable grounds is set out in the legislation, which would include if the hours of work are likely to significantly reduce, there's a significant change that would be inconsistent with permanent employment, or there's some other compelling business grounds as to why you shouldn't do it. But that's going to be assessed from the perspective that this is a benefit for workers. So you're not going to be able to easily deprive a worker of the ability to convert by some whimsical or not solid business grounds to refuse. And then you've got to provide written reasons if you do decline, and that's sort of the way in which any requests or offers being declined will be assessed. So what we can see is we now know who's a casual at commencement, but the debate will now move over to the conversion ground, and that's right for some dispute, especially for the cases around the middle. So I now want to look at real quickly and put on your radar this issue. Is my worker an employee or contractor? The old chestnut, 70 years, there has been a legion of high court cases to deal with this. Doing the control test, moving to the totality test. And we've got some more challenges, and I'm going to talk about them at the moment. They're decisions pending in those matters. But what has really brought on the uncertainty in this area, I think, is the gig economy. A lot of noise about contractor relationships being used to exploit workers, and this has led to a real pushing of the existing tests. You know, do those tests operate in a satisfactory way in the modern world? And this has created a whole lot of uncertainty. So for those who aren't familiar with the area, I just want to make a few initial observations as to what this is all about. So it's a multifactorial test. Throw everything up in the air and you work out, apparently, what the relationship truly is at law. And it is one based on impression, and we do see different results for similar cases. So it is an area where there's not certainty for business. In saying that, the test that presently exists has operated in a way that provides pretty good guidance, and I will show some of those things that are looked at in a moment. But typically issues of control, delegation and integration into the business were important, but never one factor alone was ever decisive. What I've got on the next slide, and you'll certainly get a copy of this and you can look at it, is just a list of some things that are thought about in deciding whether or not someone's a contractor or an employee, such as how you describe the relationship, what the contract says, whether someone has ABN, whether they issue invoices, whether they provide their own equipment, how they're paid, ability to delegate, obligation to rectify work, whether they get leave or not, the ability to control, the ability to refuse work, whether the contractor is performing skilled work, and a whole range of factors. And they're all worked out to sort of work out, well, what does this person as a worker really look like, an employee or a contractor? Now, quite interesting. It's certainly not an easy test to work out, and certainly what people have been doing over the years is saying, well, let's look at the worker and are they running their own business? Are they running their own enterprise? And in that regard, that line of thinking sort of popped along 10 years ago, and what the courts have said recently is that looking at it from the perspective of is that person running their own enterprise can tend to cause confusion in an area which is already replete with traps for the unwary. Okay, so that's the area we're in, and therefore the full federal court has said the question always to be asked is whether the person is an employee and not whether the person is conducting their own business. Now that certainly is the focal point, but that's not saying whether someone's running their own business is not relevant in assessing the nature of the relationship. It's just that we've got to focus on the employment. Now, this is where I think we're starting to get a shift in thinking. This is the Uber Eats case. This is the Uber Eats case where the Uber Eats driver was found by the Fair Work Commission in that balancing exercise to not be an employee because even though there were standards that needed to be met in the contract, and that's very common in a lot of service contracts, that there are standards to be met. The worker could choose when and how long they work. They could work for other competitors. That's something you don't see in employment. I don't moonlight at another law firm. And they weren't presented as an emanation of Uber Eats. So they didn't wear a uniform. It wasn't a company car and all that, but they purchased their own car. And the Fair Work Commission found that they were contractors. There was an appeal to the full federal court, some very tough questions of Uber Eats during the exchanges of the hearing, and the matter quickly settled. And that's where we can see this shift coming, at least at the federal court level. So then we get to two cases that are before the High Court, two cases which might shift the thinking. One area, I'm not going to spend a lot of time on this, but this is personnel contracting. This is an important area because it's an area which I think for a long time has been settled. This involved a company, personnel contracting, engaging a tourist, a backpacker, as an independent contractor to deliver services and to do work at a building company, Hanson. And personnel contracting, say nothing, do nothing. The person goes to Hanson and Hanson does all the control. Hanson looks after the whole kit and caboodle. And long-standing authority has said, well, in that arrangement, because personnel contracting doesn't exercise any control, it can't be an employment relationship. Control is just so important. It can't be. Now, that has been long-standing authority. That is now before the High Court. That is at serious risk of being attacked. At serious risk of being attacked, because if you say to someone, I direct you to obey Hanson's instructions, aren't you exercising control? It's just neat and simple, but you're exercising control. So that's going to be looked at. Now, I'm not going to predict how the High Court's going to rule on that, but I would suspect that may be at risk, but we'll see what happens. But that's certainly an arrangement, or it's called a tri-party arrangement, where people tend to shield themselves from the employment relationship. That is an area to watch. The next big case that I really want to talk about, and I will conclude on before handing over to Jade, is this case of ZG Operation Australia, because this is a case where I think a lot of lawyers, perhaps black letter lawyers, would have said the truck driver's a contractor, because what the truck driver did was create a partnership, purchased a truck, a big piece of machinery, expensive machinery, structured his arrangements in that partnership as a partnership business, issued invoices, had insurances, had the tax benefits of that partnership arrangement, bore the costs and risk and expense of a truck. But through that partnership, only ever drove for the one company. Had the ability to work for others. Contract didn't prevent that, but didn't actually do work for others. And the issue was whether the driver is an employee or contractor. And that real issue here was, what weight do you put on the contract? What weight do you put on the intention of the parties? And what weight do you put on the fact that his goodwill was with ZG Operations, or did he actually have no goodwill because it was only one business, and in fact he was really part of the business? And this is the debate in that case, because what the full federal court did was to recognise that, well, the contract's the starting point, but we've got to look at the totality of the relationship, and the contract can never be determinative. So you can see Rosado, High Court was leaning towards, no, let's look at the contract, let's look at certainty. We've got the independent contractor employee issue, and it's always been the totality of the relationship. So what weight are we going to give to the contract? And then when someone acts consistent with the contract, issues invoices, has their own insurances, puts their tax forms in on the basis that they're a partnership, does the contract have more weight? How does that balance out? And this is the debate that is going to be resolved by the High Court. I think we're still going to have the totality test, but how do you balance it all? Because what the full federal court said, he said, well, this person could only ever be a driver. And the fact that they delegated their work once over that long period of time doesn't really shift us. So really, really interesting debate. The last thing I want to mention, because this is the sleeper in the contractor issue, and you all need to be alert to this, and I've seen a shift with the ATO of late. With respect to employees, you've got to pay superannuation on their ordinary time earnings. We all know that. But there are workers that are deemed employees, and one of them is a person who works under a contract that is wholly or principally for the labour of the person. Now, the High Court made comment on that in ZG Operation. That's part of the issues in that case. But the law at present really says that what you look at is the contract, and you say, as the entity that's engaging the worker, whether the labour component was wholly and principally what the contract was for. So were you contracting for that person's labour? And that became clear in this dental corporation case, because Mr. Moffat was a contractor. He was engaged under such an unusual arrangement that he could only be a contractor. But because the contract was wholly or principally for him to provide dental services, they had to pay super. So don't fall into the trap of being comfortable with the contractor arrangement, being a contractor arrangement of common law, but then not think that there's this sting with superannuation. And certainly the ATO is a lot more alert to this, and I'm seeing a shift in that area. So you've got to remember the deeming provisions. With that, I'm going to hand over to Jade.
All right, thank you, James. And we're going to shift gears a little bit here and talk about restraining speech. This is something that's come up recently again following a High Court decision and, dare I say it, a lot of COVID vaccination comments. How many times have we heard do your own research? It's the only time I'm mentioning COVID, I promise. But it's something that's going to be an issue for, I think, the next little while, just while we really get our heads around what the particular High Court case actually said. So let's have a look at it in a little bit of detail and then look at how we can respond to some of these asserted freedom of speech comments. So as you may know, the case involved Dr. Ridd and James Cook University, and Dr. Ridd is shown on the screen here. And he was employed by the uni for 27 years before he was terminated somewhat controversially in 2018. And during his time at the uni itself, he did at one point lead the marine geophysical lab, but at the time of his termination was head of the physics department. Now, when he was terminated, it followed a whole series of incidents spanning several years. We're not going to go through them in detail. Suffice to say that Dr. Ridd was actually censured a couple of times because of some very public derogatory comments that were made, both about the university, some of its research findings, especially around the Great Barrier Reef, and also some of its sponsors as well. And these were made quite publicly, including on a Sky News interview. Dr. Ridd, as I mentioned, was censured, but he continued on, and eventually he ended up breaching confidentiality surrounding his own disciplinary process as well. So he did go one step further than simply making comments and go a little bit further there. And eventually, the uni did terminate Dr. Ridd for breaching 18 different factors of the Code of Conduct. Now, the interesting thing throughout all of this process, from beginning to end, is that Dr. Ridd never actually disputed that he engaged in serious misconduct or misconduct at all. Dr. Ridd instead relied on a term that was contained in the uni's enterprise agreement, which essentially, I'm paraphrasing here, said that intellectual freedom is to be protected, and Dr. Ridd asserted that he was simply exercising his intellectual freedom. The university, on the other hand, relied on the Code of Conduct and found that he had breached that and therefore warranted his termination. Now, in his first instance in the Federal Circuit Court, I need another coffee, Justice Vasta found in favour of Dr. Ridd and awarded him $1.2 million. And went on to actually discuss the nature of universities and their role in society, and made this comment that's up on the screen now, saying that intellectual freedom is so important. It allows academics to express their opinions without fear of reprisals. It allows a Charles Darwin to break free of the constraints of creationism, and Albert Einstein to break free of the constraints of Newtonian physics, and allows the human race to question conventional wisdom. Honestly, this case is just ripe for these types of quotes. That's a very, very good summary of how we tend to conceptualize intellectual freedom. So as I said, Dr. Ridd was successful in the first instance and awarded $1.2 million. Unsurprisingly, the university appealed the decision and was actually successful at the full federal court. And Dr. Ridd this year has appealed the matter to the High Court. Somewhat surprisingly, Dr. Ridd was wholly and completely unsuccessful. The High Court did examine the nature of intellectual freedom and did so quite eloquently, in my opinion, but they ultimately found that none of Dr. Ridd's conduct was actually covered by it. So it was unhelpful for Dr. Ridd personally, but the High Court decision did give us some guidance about what intellectual freedom is in modern Australia and how it's applied. And there are really, the way to conceptualize it is that's not a free, unfettered freedom to say and do whatever you want without fear of reprisals. There really are three important limitations, and you can see them on the screen now. The first one, and one that I think people really need to understand, is that intellectual freedom is not a general freedom of speech. It's very much limited to freedoms within your area of competence or speciality. So as an academic or as an expert, you can have those rigorous debates. You can engage in back and forth. You can have that really tough discussion, express your opinions, controversial or otherwise. But for want of a better phrase, stay in your lane. Stick to your expertise if you want to claim intellectual freedom covers or protects your conduct. The second point that came out of this case quite clearly is that employees are not free to disregard their employer's complaint process and rely on academic freedom or intellectual freedom. In this case, JCU did actually have in place complaint mechanisms and complaint processes. Dr. Ridd simply elected to not follow any of those and to make very public complaints instead. So if you want to claim intellectual freedom, you still have to follow the employer's policies and procedures. And finally, one that does need to come out is that if a process or a comment or a proceeding has a confidentiality requirement to it, intellectual freedom is not some get out of jail free card. You still have to comply with that confidentiality requirement. It's not waived. In this case, there were some very sound and robust reasons for why confidentiality was in place. It wasn't arbitrary or random. It was very much put in place for a solid business reason, and there was no reason in this case for it to be breached. And intellectual freedom doesn't permit obligations like this to just be ignored. So what can employers do about intellectual freedom? We've started to see some of this emerging, as I mentioned before, when we talk about COVID cases, COVID vaccines especially. So, and we often see it now appearing on social media. Dr. Ridd's comments did involve Sky News interviews, but social media, Facebook, Instagram, they're starting to arise as well. So what can employers do? First and foremost, have a policy. A policy is still an incredibly useful and valuable touchstone when attempting to regulate employee behaviour. And it also provides great guidance on how we can respond to it. Now, if a comment has been made or has been posted somewhere, stop, take a breath, and just ask yourself, has that employee's opinion and conduct really been brought into the workplace? Is it simply expressing an opinion outside the workplace? Or have they gone ahead and breached some policies or procedures that are in place? Have they breached confidentiality? Have they gone against a lawful and reasonable direction? For example, James and I might have very different political views. I could potentially post something that James disagrees with on Facebook. Has that actually brought it into the workplace? Have I gone against some policy or some direction from him? That's what we need to actually look at, because it will determine how we proceed. Once we've had a look at that, then it's important to actually stop and assess the effect of this. Have the employee's actions damaged our business, damaged our reputation? Do we have clients screaming at us down the phone? Or have they damaged or potentially even damaged the workplace relationships? Can other employees work with this particular employee? Or are they refusing to? And that's starting to rise up where people are refusing to be vaccinated or similar arguments to that. And finally, it's also important to assess the expectations. Bear in mind, as much as we may hate to admit it, a newbie or a junior person speaking out against a company will carry different weight and different gravitas to if a CEO who is known to be the public spokesperson for your company speaks out. There's different weights to them and different expectations from the public and to some extent, possibly from the company as well. And I think it's very important to just bear in mind to not be overly sensitive and try to be some sort of morality police. Your role here is to guard the organisation's reputations and its values. It doesn't necessarily mean that you have to police every single employee's beliefs or morals, but we do have to guard the organisation's reputation. And that can be a bit of a grey area, I fully realise that. So every organisation really needs to kind of find its own position in that grey and really enforce its own values. So this is something that certainly does apply now, But it's something that's always coming up, and as social media continues to evolve, it's something that we really do need to keep on top of. We're going to switch gears slightly here and just talk about sexual harassment. I know it seems like we're kind of covering all the depressing topics right now, but I think it's actually something, the changes in sexual harassment, something that are actually potentially quite positive. So sexual harassment in the workplace has been a hot button topic for several years, thanks to the Me Too movement, but we've seen a couple of very significant changes recently, quite recently, in the legislation. And these all largely stem from the Respect at Work report that was released in January of 2020, so almost 2 years old now. Now, this report was prepared by the Sex Discrimination Commissioner, Kate Jenkins, and it's a hefty read, and it is quite a sobering read. It covers quite a range of areas, and I think one of the most confronting conclusions that came out of this report is the conclusion that's on the screen. Workplace sexual harassment is prevalent and pervasive. It occurs in every industry, in every location, and at every level. So a bit of a wake-up call for people and organisations who perhaps thought that they had dealt with sexual harassment. It's still very much a part of society right now. Now, the report itself, I do realise how long it is, but the report proposed a package of 55 recommendations, and I do suggest that you actually read those. Of those recommendations, 5 of them have been adopted, and one of the ones that's been adopted is to provide the Fair Work Commission with new powers very similar to the Stop Bullying or the anti-bullying jurisdiction that it previously had. And these powers came into force quite recently, just on the 11th of November. So it's still very new, very much change and watch this space. But it's important to note that these legislative changes, which we'll look at in just a second, aren't happening in isolation or in a vacuum. They're also being mirrored when we look at the way that courts and tribunals are approaching damages for sexual harassment. And there's quite a recent case, and it's the case of Golding and Sipple and the laundry chute, which is up on the screen there. It's a Queensland case, but it's actually quite on point and provides some good guidance here. Now, Ms. Golding was a casual employee at a Brisbane-based laundromat, and over the period of 14 months, she experienced some pretty shocking behaviour. She was offered money and or a lawnmower in exchange for sexual favours. She was repeatedly propositioned for intercourse. She was sexually assaulted and she experienced sexual discrimination. And all of this culminated in a series of text messages between Ms. Golding and her employer in August of 2018, which actually prompted Ms. Golding to approach the Queensland police regarding the matter. And the police allegedly told her that it was not safe for her to return to the workplace. So it's a pretty egregious situation here. Now, Ms. Golding initially was before the Queensland Commission, and she was in first instance, she was awarded just under $16,000 in economic damages and $35,000 for general and aggravated damages. And this was appealed to the Industrial Court of Queensland. And on this appeal, President Davis held that the general and aggravated damages should be lifted because they were manifestly inadequate. And the President Davis went on to state that Mr. Sipple's conduct was extremely serious. Over a period of 14 months, he tormented Ms. Golding, a woman who had little choice but to work for the laundry chute and put up with him because of her financial position. That was the reason why she tolerated his lewd and disgusting behaviour. And every day she appeared for work, she knew the prospect was that she would be humiliated and demeaned sexually by him. And this ultimately resulted in Ms. Golding developing an anxiety disorder and affecting her ability to work. So in light of all of this, President Davis substituted an award for economic damages of $29,000, so a $13,000 increase, and most importantly, an award for general and aggravated damages of $130,000. So that's an increase of $95,000. Now, perhaps I'm being overly optimistic or naive on this one, but I view decisions like this one, along with the legislative changes that we'll look at in a second, perhaps as indications that the courts and the tribunals are changing in their attitude and reflecting a lot of society's attitude now towards sexual harassment in the workplace. So, as I mentioned, there have been a couple of changes quite recently to the Fair Work Act, and there are two in particular that I just want to spend a little bit of time on today. And the first one is that it's now been formally recognised that sexual harassment can be grounds for a valid reason for termination. So Section 387 of the Fair Work Act, as you can see on the screen, has been changed to provide that it is a valid reason to terminate somebody's employment if that person has sexually harassed another person and that sexual harassment occurred in connection with the person's employment. So to me, this really gives employers a little bit more strength, or should give them a bit of confidence to tackle sexual harassment in their workplace. They can take that extra step and potentially terminate an employee and possibly have it be held to be a valid reason. Of course, depends on the circumstances, but there's that little bit of extra support and extra encouragement for employers to take that extra step. Now, of course, in connection with a person's employment is always going to be the crucial part of that test. And as I mentioned, new provisions, we don't have any legislative or case law guidance on this point, but it's likely that in connection is going to follow the same type of test that we see for out of hours conduct, okay? And the second thing, or second change that I'd just like to spend a little bit of time on are the new Stop Sexual Harassment orders. So these orders can be issued in circumstances where an employee has been sexually harassed at work, so that's your first criteria, by one or more individuals, and the Commission is satisfied that there is a risk that the worker will continue to be sexually harassed at work by the individual or individuals. So it's a two criteria test. And then the Fair Work Commission may make any order, of course, except for financial penalties, to prevent the worker from being sexually harassed. And in this case, sexually harassed has the same meaning as in the Commonwealth Sex Discrimination Act. So it's essentially unwelcome conduct of a sexual nature that a reasonable person would have anticipated would cause humiliation, intimidation, or offence. Paraphrasing, of course. Now, importantly, the orders can be made here potentially from one single instance of sexual harassment. Unlike the bullying jurisdiction, there's no requirement that the behaviour be repeated. And nor does there have to be an examination of the behaviour to see whether or not it's caused any risk to health or safety. However, the flip side to this is that the Commission must be satisfied that there is a risk that the employee is going to be harassed again in the future. And we don't know what risk level is required. It doesn't have to be a significant risk. It doesn't have to be a minor risk. It's not clear where the risk state is going to kind of settle for the Commission. It remains to be seen if we need some concrete risk. So, for example, let's say we have to make presentations on sexual harassment and I was harassed during that presentation, and part of my role is I have to do this type of presentation repeatedly. That may be a concrete risk. Or is it simply enough that an employee is going to be reasonably concerned about being put in the same situation and exposed to the same type of harassment in future? We don't quite know where the Commission is going to land at that one. And it's also worth pointing that it's talking about harassment at work. It's not clear if that will just be limited to at the workplace or more likely encompass out of hours work. So I'd definitely beware the Christmas functions as well. So what approach is the Commission going to take in this one? We think it's going to be fairly similar to the anti-bullying jurisdiction, similar types of provision and similar goals. So what should employers do at this stage? It's definitely not a case of panicking, but based on what we've seen from the Stop Bullying Order jurisdiction, employers really should take the time now to ensure that they have in place appropriate measures to stop sexual harassment in the workplace. This could be policies. If you haven't reviewed yours lately, it'd be worth checking it now. Training both for new and old employees, rolling it out again, and putting in place reporting pathways and investigation procedures that are appropriate. Noting here that the Respect at Work report really did encourage employers to adopt a victim-centred approach, which may be different from the ones that are currently in place at the organisation. And something that I think we should be aware of that we may end up seeing in the future are what I've described as combination claims here. So we may see stop bullying orders being applied for at the same time as stop sexual harassment orders. And we may also see combination orders directed at employers. So for example, we may see stop sexual harassment orders directed at a particular employee, but we may also see general protections claims arising at the same time if the employer perhaps suspends or stands down or relocates the victim in this case. So we may see a bit of a combination of all of these working together, which could be quite interesting to see how the Commission untangles all of these situations at one time. So very much watch this space. I think it's a good step forward, but it's something that, as we mentioned before, is a change and is in a bit of flux. And speaking of change, I'm actually going to hand back to James to have a discussion about what we may see coming early next year.
Yes, thank you, Jade. The Great Resignation, as it's called by the media, and I've got to say I have started to see a little bit more focus on the fight for talent. I can't say I've seen or had clients experience mass exodus or the Great Resignation as it's described, but certainly there has been a real push for talent of late, and indeed trying to retain one's existing talent, and that cries a lot to good HR, good culture, good values, and what can I add here as a lawyer? So what I'm going to talk about in terms of where I see the issue coming from an employment law perspective in this area is really in 5 key areas. First of all, when I've seen this year after year after year, whether it's talking to businesses or whether it's talking to workers that have resigned, but this belief that this notice period is an entitlement to be paid and do nothing. A notice period is a period you give so that way the business or the employee can adjust to their circumstances. It's not a get out of doing your work card. And whilst you are in the notice period, you are still employed, and you are still employed to perform your role as required by the contract in full, not half a job, not a quarter of a job, or not no job. And an employer has a right to say, I'm not accepting part performance. If you don't give me full performance, I'm not paying you. A notice period is a period where not only are you looking at transition, but you're entitled to still get the bargain that you've contracted for. Because as far as I'm aware, I haven't seen any ability or provision in a contract that says, oh, during the notice period, we can reduce your pay to 50% because you're only going to give us 50% effort. It doesn't exist. The next important point that I'm seeing in resignations of late is the employee controlling the message. The employee telling workers and clients their message about leaving. That's not the employee's role. It's very common in policy or in contracts to say that the employee doesn't have the authority to speak on behalf of the business. And employers should be controlling the messaging actively and being on top of that immediately and telling the employee they don't have the authority whilst they're employed to just go and talk to clients and tell them they're leaving, particularly when they say, oh, look, I'm leaving and I can't tell you how the business is going to manage the handover. I mean, it's just setting up for the client to be lost. Confidentiality, good faith duty still applies in the notice period. Too many hello McFly moments I see where employees resign and then they're downloading or sending to home confidential information. I would have thought people realise by now that IT networks can work it out, but it follows to my fourth point, which is about protecting the business, is that you've got to start looking at ensuring in that period that your confidentiality, that your IP and that your clients are protected. And we can see how also messaging interplays with that. Managing the departure of an employee, not only from a cultural perspective, but from a business protection perspective, requires a holistic approach and an active management of that. And you know, certainly one of the parts of managing that might be to put an employee on gardening leave. That's when you have them still as your employee, but at home, not attending work, rather than end their employment immediately and pay them out. You have them on gardening leave, and the benefit of that is the duty of good faith and fidelity still applies. So they're still got to comply with your instructions and your requirements with respect to communication with clients. They still can't, they can't go and start working for the new business because they're still your employee. And the last area to keep in mind is post-employment obligations. And certainly for a lot of you here in HR, you're going to be managing the expectations of your business leaders. And they're going to come from the approach of, well, if it's in the contract, why is it not enforceable? And the reality is you put what you can put in the contract in the hope that you've got something to rely on, but we all know post-employment restraints are an area of contest. There's not certainty because a lot is fact dependent upon the worker's position, their level of access to confidential information, their level of client access, and you know, restraints preventing people from going to work from a competitor. You're unlikely to be able to enforce. Restraints against poaching clients, particularly if they deal with clients, you're more likely to be able to enforce that for a reasonable period of time. It's probably all in the contract, so that way you've got the protection if it's available and needed, but there's got to be a need to manage the expectations of the business leaders in terms of what you might be able to actually enforce. And certainly part of the discussion that you need to be having with the worker during that notice period is about saying, hey, our protections are important to us. It was part of the bargain, and start to make clear as to what's important and what you're going to uphold, but don't make bold, unrealistic threats that you might not be able to enforce, such as non-competition restraints. They're going to be difficult unless the person is really the face of the business. So we're going to move to questions now. I did see a question that said, is there any update on vax cases? And we said we wanted to avoid that, but here we go. Let's have a little update. I'm sure we're all a bit fatigued by it, but it is an area where we're going to get some certainty. So what we know at present is this. When it comes to aged care, childcare, and health sector, the mandatory flu vaccine as a requirement of employment has been upheld as a lawful and reasonable direction. There's probably no reason to think that there should be a different approach with COVID, but we don't have any direct COVID cases as yet. What we do know is the New South Wales Supreme Court has looked at the public health orders. Public health orders are sort of like a mandatory vax policy. They're not, because they're made under public health legislation and have stronger force, but similar sort of concept and requirement. And the New South Wales Supreme Court in 2 decisions have just rejected the challenges to it. Those challenges have included a whole lot of the dribble that you see employees that don't want to get vaccinated download from the web and send to you in nice long lengthy letters about international conventions, discrimination, assault, etc. The Supreme Court has not been impressed by them. What we did have is one member of the Fair Work Commission in a dissenting decision almost cut and paste all of those arguments in their decision and said, you know, for that reason, you can't do mandatory vaccination. The majority decision said we're not even going to entertain those arguments because they have no basis. The New South Wales Supreme Court was very critical of that dissenting decision and really said that the Commission shouldn't engage in political pamphlet or political comment sort of activity. So a rather scathing attack on that negative decision. So then we get to today where there's an actual mandatory vaccination policy case before the full bench of the Fair Work Commission being heard on the 24th of November to do with the mining industry. Again, it's going to be industry specific and fact specific to that case, but it will provide some guidance and we expect a decision in early December. Sitting here right now, I think employers who genuinely assess that there's a risk of transmission of COVID in the workplace, and you know, as I say, COVID doesn't worry about the distinctions between different types of people, different type of workers. It just needs two people and it will jump. It's what it does. It's what it likes to do. Party time when there's social interactions. So, and that's what workplaces are. It's a place where you come to work and interact. So the risk exists, and what we do know is there's a significant risk of illness and death if you're unvaccinated. We know that that risk is there in a significant and real way if you're vaccinated but you're compromised. And not everyone knows if they're compromised or not. Some people think they're fighting fit, and they might be to the extent to what they don't know. And certainly vaccination is the best way known at present to provide protection both as to transmission and as to the impact and effects of it. So from a work health safety perspective, there's reason for it, there's a logic for it, and it's likely to be lawful and reasonable, and I think employers can sit with a bit of comfort on those policies, but like many things, it's a wait and see approach. Now, there's a question that's been asked, what is your opinion on immigration in 2022 and skill shortages? Look, from a employment law perspective, we're not migration accredited lawyers, so I can't really comment on that. I'm not going to predict what's going to happen in 2022, but certainly there are labour shortages, and it is something that businesses are looking at, and I'm aware that it is on the radar for businesses and the business community, and expect that we will see some movement in that area. But certainly, you know, it will be important, regardless of the requirements that are in place for quarantining and the tests that come in beforehand. Businesses would need to make sure that, you know, any worker that comes from overseas, whether they're coming for work purposes or whether they're returning from a holiday that we've just booked to head off overseas, you would certainly want to be looking at any returning workers, you know, perhaps having a negative test result from COVID before they return to the workplace, much like the issues we were thinking about in 2021 about returning to the workplace after the first wave. So with that, thank you everyone for attending. May you all have a safe, enjoyable, relaxing Christmas and New Year. We look forward to seeing you next year. Hopefully there's more certainty, but I'm not going to predict what next year's like. That's thrown out of the water. Thank you, everyone. Bye.